Hello, this is Dr. Prasad Podilam, the class of on research methodology and intellectual property rights with the subject code BRMK 557. This is for the 2022 scheme students, those who have joined the Vishweshwaraya Technology University in the academic year 2022-23 onwards. Okay, so previous year 21 scheme that also study material is there. That is 21 RMI 57 that is available in my YouTube channel. The module 1 and module 2 are exactly the same, so I have not taken an extra class series or class on that. Module 3 I covered. This is module 4. So what are the analyzing the previous syllabus? What are the new topics added, we covering it more and even introducing the old topic. I have prepared the questions and my explanation will be based on that compared to the previous last year's videos. So my YouTube channel name is my intuition 4865. Please do subscribe to this YouTube channel. Your subscription is my support, and share it to your classmates or your friends who are studying in the 5th semester of Vishweshwaraya Technological University. This is a common subject for all. It's a descriptive type question. We need to elaborately write the question answer for this type of this particular syllabus. So this is the syllabus for module 4. As mentioned, I am not reading it completely. You can pause it and check it out. Okay, so the topic which I am covering for the first question of module 4, that is classes of copyright, criteria for copyright, ownership of copyright, copyrights of the author. Okay, so question number 1. Question given as explain the criteria for obtaining copyright protection for a work. It is mapped to course outcome 4, and its level is maintained as 2, revised Bloom's taxonomy level 2. Okay, so answer scheme or the points which needed for to answer this, to elaborate this question as an answer. Originality. So the work must be original and created by the author. The originality means that the work that we create, it must be new and not copied from someone else. So it has to be something that we made ourselves using our own ideas and our efforts, which ensures that only new creative works are protected by copyright. Means if you write a novel about a magical adventure, it is a story that we came up with our own effort and considering its originality. But if we copy the plot and character from other authors' book, then our novel is not original. For example, if we create a new song with our own melody and lyrics, that song is original. But if we just copy the melody from an existing popular song and use it as our own, it is not considered original. When I say the song, when the Kantara movie was released, there was a issue happened, but later it showed that both tunes are different. It was not a copy. So that case we have seen in the newspapers. Now, second point, that is fixation. Fixation means fixation. The work must be fixed in a tangible medium, such as written, or recorded, or even painted. So fixation, it means that the work must be put into a form that can be either seen, it can be heard, or it can be touched. So this could be writing it down, or recording it, or creating it on paper. It needs to be in a physical or digital form, which can be stored and accessed later. Means if you compose a piece of music and write it down on a sheet music with that notes under, that's fixation. If you paint a picture on a canvas, that is also fixation. Even if you record our song on our own phone or computer, it is fixed in a tangible medium. I'm recording my video to my YouTube channel, publishing in my YouTube channel. This big session. So, however, if I just think of an idea for a story, but never write it down or recorded it, it is not fixed and therefore not protected by the copyright. Okay. Third point, expression. Copyright protects the expression of an idea, not the idea itself. That is idea expression dichotomy. Expression, it means that copyright it protects the way we express our ideas, not actually the ideas themselves. So this means we can protect our unique way of telling a story, drawing a picture, or composing a song, but not the general idea or concept behind this. If we write a novel about uh, that one, but I can need to tell something about a school. Copyright protects our specific story, our characters, the writing style, but it does not protect the general idea of a magical the story creator or the school. If another author writes a complete different story about similar type of a school with different characters and plots, they are free to do so. For instance, the uh, the Harry Potter by J.K. Rowling. The Harry Potter series is protected because it is a specific characters and stories. But the general idea of such a school, a magical school, it is not protected. So other authors can write about similar themes as long as their stories are different. Okay, I'll go to the next topic, sir. That is copyright infringement. Copyright infringement as a criminal offence. Copyright infringements as cognizable offences. Fair use doctrine. Copyright and internet. So a question is framed as describe the key elements of the fair use doctrine in copyright law that is connected to course outcome 4, having the revised Bloom taxonomy level of 2. Answer scheme, if we check the purpose and character of use, the use should be for educational, it should be for conducting research, for commentary, or even non-commercial purposes and characters of the use here. It means that using the copyrighted material for certain purposes, like I said, teaching, research, or commentary, it is often allowed, and it is a fair use doctrine because such uses are generally considered very uh, benefit or beneficial to the society and do not aim to make a profit. For example, the educational use, um, educational content creator, YouTuber like me can use the short expert from a book to explain in a classroom presentation to to help the students to understand the concept. This is can be treated as okay because it is for the educational purpose. References need to be shown. If I consider the research use, a researcher, he may quote a few lines from a research paper in his own paper in order to support the arguments. This is also acceptable because it is for a research, to connect the two terms to their arguments. Then commentary use, a film critic, it might include the short clips from a movie because you need to criticize it. So yeah, you need to show that part of the movie in their review to discuss the film. Okay, so this is also okay for the commentary. Non-commercial uses uh, means posting a few lines from a book in a personal blog content creator, again the YouTuber, without using it as an ad or without ads, to discuss the content. It is also a fair use. Moving to the next topic, next point, that is nature of the copyrighted work. Some works are more easily considered for fair use, like the factual works compared to the creative works. The nature of the copyrighted work, it refers whether the work being used is more factual or creative. Factual works like the news articles or the scientific papers, they are often more likely to be used fairly than creative works like the novels or music, because they are meant to share the information. The factual work, if I take an example, when we quote a few sentences from a news article about the current events, it is more often more likely to be considered fair, because the information is factual, based on the fact, and it is intended to be informed, to inform. Creative work, if I consider using parts of a novel or a song, it is less likely to be fair, because these are creative works where the expression is unique and it is the original. Moving to the next point, amount and uh, sustainability. It means that when we use copyrighted material, we should only use a small part of it. We should not use the most important or the key parts of the work. This helps to ensure that our use doesn't replace or overshadow the original work. Limited use, when I say, if we quote a short paragraph from a book to make a point in our own writing, it is acceptable. However, if we copy an entire chapter, that is not fair. Then the core essence, using a brief clip from a movie in a review, it is generally, it can be treated as okay, but showing the entire movie should not. It is too much. Okay, so fourth point, effect on market, means we use copyrighted material should not harm the original work's ability to make money. If our use could lead people not to buy the original work because they have seen it or read it elsewhere, it might not be considered as fair use. Positive and negative impacts are the positive impact. If a teacher uses a few pages from the textbook in a lesson, it is unlikely to affect the textbook sale, because the student still needs to buy the textbook for complete information. So it may be more giving advertisement to the book. So it is a positive impact. The negative impact, when we say, if we upload an entire popular song which is not yet released to public as such, people has to purchase. If you upload it to a public website where anyone can download it for free, then it might hurt the artist's sale, because people might not buy the song if they can get it for free. Going to the next topics, copyright registration, judicial powers of registrar of copyrights, fee structure, copyright symbol, validity of copyright, copyright profile of India. Question: what are the steps involved in registering a copyright in India? Course connected to course outcome for revised Bloom taxonomy level, it is 2. So the first point in answer scheme, that is filing application. Filing an application, it means that we need to fill out a form and send it to the copyright office. This form includes the detail about our work, like what it is, who created it. We also need to pay a fee, which is like a small payment for processing the application. Second point, that is examination. Examination is when the copyright office they check our application in order to make sure that everything it is correct and it is complete. They look for any mistakes or missing information that might need to be fixed before they can register our work. Just like a teacher checking your homework for errors. If a teacher finds a mistake, they will might ask you to correct them. That's all. It's not that the patent or this one is rejected. Then hearing. Next topic, hearing. Okay, hearing if there are objections may be scheduled. If there are problems with our application that cannot be fixed, just by correcting the mistakes, the copyright office might arrange a hearing. This is a meeting where you can explain your case or our case with and respond to any objection or concerns raised by the office or others. Okay, I getting only that much for that. Registration. Once approved, the copyright is registered and copyright symbol that C in a circle, that symbol, it can be used. So registration, it happens when the copyright office approves our application. After approval, our work is officially protected by copyright law. We can use the copyright symbol to show that our work is protected. Yes. Fifth one, that is certificate issuance, issuing the certificate. After our application is approved, our work is registered and we will receive a certificate of registration. And this document officially proves that our work on the owning the copyright to our work. Okay. Just imagining that to get a diploma after graduating from the school. The diploma is a formal document which provides us the complete that we completed our studies. Same way, if a copyright things are completed, we'll get a certificate. That is called a certificate of registration. Topics: copyright and the word publish, transfer of copyright to a publisher, copyrights and the word adaptation, copyrights and the word Indian work, joint authorship, copyright society, copyright board, copyright enforcement advisory council. These are the topics in the syllabus. Based on these topics, question is framed like what are the key factors to consider when transferring copyright to a publisher? So that is connected to course outcome 4 with a revised Bloom taxonomy level of 2. Okay, so scheme first point, that is license and assignment. These are two ways in order to transfer the rights to a creative work. Here, license means giving permission to someone to use our work, but still we own the rights. So this is like renting our car. The renter can use it, but still car is ours. Assignment means giving away all our rights to someone else. Just like we are selling our car. Once we sell, then we have no author, or we cannot own our. It is no more ours. Second point, that is duration. Duration, how long? It's about how long the rights we have or we give away or allow someone to use our work will last. Okay, this can be a specific time period or until a certain event happens. For example, we are giving our car for rent. In the rent agreement, we have to specify till which year or which month he can use it, and afterwards what has to be done. Or if you license a photograph to a magazine for say about 1 year, that our photograph should be published in that magazine. The magazine can use not that the magazine is giving us this one, that we are giving permission for the magazine to publish our photographs what we taken as a very good wild photographer. Then they will, once the license expires, then they cannot further use it. So further they have to revise or renew the license. Okay, to renew the license again, they may have to pay some royalties. Like, okay, so royalties are payment which are made, to the one who created when the work is sold or it is used. It is like getting a percentage of money from the sale. Means if we write a book and we publish, and the publisher sells it for some 250 rupees or 200 rupees, it means some 2 rupees for every book it can be given as a royalty. So that the publisher has to decide, or the author has to decide when during the agreement. Okay, so the more books are sold, the more royalties we receive. Then comes the adaptation rights. Adaptation rights are about whether someone can change our work into something different. For example, turning our story book into a movie. That is adaptation right. Okay, so further topics like international copyright agreements, conventions and treaties, interesting copyright cases, trademarks, eligibility criteria acts, designation of a trademark symbol, classification of trademarks. Registration of a trademark is not compulsory. A famous case law like a Coca-Cola Company versus Distillery International Private Limited. These are the most last topics of this module 4. Question is found like discuss the significance of the Coca-Cola Company versus Distillery International Private Limited case in trademark law. So this is almost a sure hit question for exam, because it is not was not there in the previous syllabus. Now it is there. So it is very non one. So everyone should answer this question. Should know this question answer. Okay, so the background, that Bisleri, no Bisleri company, the drinking water bottle company, they had a brand called the Maza. Maza is it was a very popular drink. Bisleri decided to sell the rights of using the name Maza to a company called Coca-Cola. After selling these rights, Bisleri they even tried to sell a drink with the same name Maza in India. Okay, so that is the background of this issue. So just imagine that we have our own bakery and we sell the names sweet treat or something sweet potato, like that, some names to another bakery. After selling the name, we cannot open a new bakery with the same name. If you try to use the same name, then in our new bakery it will be a problem. Okay, so issues. What is the issue in that? A trademark, it is a special name or a logo used by a company to identify their products. Since Coca-Cola brought the rights to the name Mazda, only Coca-Cola had the legal right to use that name. When distillery tried to use Mazda again, it was a legal problem called trademark infringement. Then what is the outcome of this issue? The court is like a referee which makes the decision about the legal issues. In this case, the court agreed with the Coca-Cola company that, and they decided that once distillery sold the right to the name Mazda, distillery could not longer be used. It should not use the name Mazda. So the previous owner of distillery, he must respect the new owner's rights. What is the significance of this? This case is very important because it shows why it is very crucial to clearly understand and follow the rules when transferring the rights to a trademark. Intellectual property includes things like brand names, logos, which are created by people. Properly managing and protecting these rights, it will always help to prevent confusion and the legal disputes. Yes, that's about answering to this question. That's about module 4. Please do once again requesting, please do share my videos to the 5th semester students of Visvesvaraya Technological University. Please do like, please subscribe and support. Thank you very much.